Lunch is imminent, so we better get started. Now, how are the acoustics? You've at the back, everything good? You can hear loud and clear? Good. Right. I am going to speak briefly and in general terms, and then the instructive and educational and interesting part of the talk will come from Carola in a moment. But I'm just going to offer a few thoughts about the making of allegations of impropriety against professionals. The title, which was foisted on us by someone, is a bit odd. Playing nasty is, it's an interesting title. It's a slightly odd title because if a claimant is in a position in which there is not sufficient material to justify an allegation of impropriety, but the claimant, backed by its lawyers, decides to make an allegation of impropriety anyway for strategic or tactical reasons, then that would qualify as playing nasty. It would also, obviously, as you'll all know, qualify as serious misconduct, because one is not permitted to make such allegations without reasonably credible evidence to back them up. So I'm not going to be spending much time contemplating lawyers getting together to advance what are essentially bogus tactical cases based on purported but non-existent impropriety, because no one in this room would get involved in that sort of thing, and if they did, they'd be off to see the SRA. So we needn't waste time with that. We're going to be talking about cases where there is material that justifies allegations of impropriety, and therefore it's not so much playing nasty. You could say it's playing hardball. It's raising the stakes, choosing to raise the stakes by pleading, formulating an allegation of impropriety. Well, even if one has available sufficient evidence to support a pleaded case of impropriety, there will often be quite compelling reasons militating against a decision to put the case as one involving impropriety. First, the effect of making such an allegation but then failing to establish it at trial in front of a judge who hears the witness or the individual or the party who has been accused of impropriety and decides that he or she has really done nothing wrong. The effect of that is often very undesirable indeed, because you might well have a good case on the basis of formulations that do not allege impropriety and put the case somewhat lower. But in my experience, one can lose a case as a result of the adverse momentum generated by a judge looking with disfavour at counsel who has put his name to an allegation of impropriety which the judge doesn't really think should have been made and certainly is not prepared to find proved. So that's one quite good reason for being cautious about formulating a case on the basis of some sort of conscious impropriety. Another reason that operates another factor that operates in the same direction, of course, is insurance. One has to be aware of the danger that making allegations of dishonesty or something like it might threaten the validity of the insurance cover on which one is relying to get paid out. And a third factor to be borne in mind when deciding whether to make the serious allegation of impropriety is an obvious one. It raises the temperature. It can raise the temperature very considerably indeed if the target of the allegation believes himself or herself to have done nothing seriously wrong. And you can get into a situation in which the case moves inexorably towards trial because no concessions whatever are made in the light of the defendant's genuine belief that an allegation of impropriety has been wrongly made. So those are all reasons for being really quite cautious about formulating a case in impropriety. Carola, in a moment, is going to be looking at, as it were, at the other side of the coin and seeking to identify the various hard-edged legal reasons why one might well want to allege some form of impropriety, dishonesty, some form of conscious wrongdoing, some form of bad faith. And you'll be hearing from Carola about that in a moment. I'm going to add a few words at the end of the talk, wrapping up some of the points. Before I sit down and let Carola speak to the law, as it were, I'm going to offer a little bit of ancient history, which of course I'm relatively well qualified to do, and take you back to the 1990s when professional negligence litigation really started to sort of gather speed in this country. In the 1980s, the textbooks on the subject were something like 200 pages long. You now get 1,000 pages plus in the main textbooks. It was in the 1990s that things warmed up, and as many in the room, but not all, will know and will recall, there was a very considerable quantity of litigation between lenders who had lost money as a result of lending shortly before the property crash of 89 to 1991, and professionals, insured professionals, who it was thought might be able to make up some of the losses that had been sustained. And obviously the favoured targets were valuers and solicitors. And it was at around that time that practitioners on the claimant side started to give some thought to developing new formulations of the relevant claims, which did not rest solely on allegations of negligence, but which used certain equitable and trust-based concepts on the one hand, and allegations of impropriety on the other hand, in order to enhance the prospects of the lender claimant, as it were, scooping the pool, getting compensation which reflected the entirety of the loss that had been sustained as a result of what was often a spectacularly unwise lending decision. So that was the context in which the law moved on quite fast in the 1990s. And I'll just mention a couple of ways in which the law developed in this area, and then offer you one anecdote about an incident in court in the late 90s, which reflects the unpredictability and the hazardness of the hazards that arise when allegations of impropriety are made. Obviously, Target was a case in which equitable concepts were used for a time to justify giving lenders, awarding lenders damages which represented the entirety of their loss. That's not part of this topic, but that was going on in the mid-1990s. The House of Lords dealt with that and said, no, that doesn't really work. You've still got to prove something resembling real causation. But meanwhile, those acting for lender claimants had a brainwave of a different sort, and they'd started to allege breach of fiduciary duty, sometimes making it clear that they were alleging some form of conscious impropriety, some form of improper conscious preference of the borrower client over the lender client, sometimes not. But anyway, lobbing out an allegation of breach of fiduciary duty. Somebody turned up, an obscure Privy Council authority, which seemed to say that if you established breach of fiduciary duty, you didn't need to prove causation. It was going to be presumed in your favour. And for a year or two, claimants' advisors used to get on the train down to Bristol, because often in Bristol, not always, and come back about 30 minutes later with summary judgment for the entirety of their loss. And they had a very good time, and the indemnity fund didn't like it at all. In fact, I think it contributed towards the sad, and some would think very premature, demise of the indemnity fund at the end of the decade. So that was going on. The Mothew case, which many of you will know, Bristol and West Building Society in Mothew, eventually got up to the Court of Appeal, and Lord Justice Millett put things straight when he said, well, this is all a confusion. True it is that solicitors are fiduciaries, but that does not mean that every case involving a breach of duty by a fiduciary is a case of breach of fiduciary duty. That is simply a confusion or a conflation. In order to establish breach of fiduciary duty, you've got to prove some sort of conscious impropriety, and that, because it's hard to do that against solicitors and other professionals, that caused that particular deployment of allegations of impropriety to fade away, not disappear altogether, but to fade away. That was the background, the case law background, as it were, to the Bristol and West litigation, which was heard in front of a very formidable Chancery judge, whom some of you will recall, he was then called Mr. Justice Chadwick. He then went to the Court of Appeal, now retired. Very formidable practitioner and judge indeed, he was practicing the Chancery bar, but nonetheless, I think the SFO or its equivalent thought it appropriate to instruct him to prosecute the Guinness 4 in some massive case of criminal fraud at the Old Bailey. So to be able to do that, but also to flourish as a silk at the Chancery bar, indicates that he was both legally very accomplished indeed, and still is, I'm sure, and was very formidable. Well, he was sitting in Bristol and getting rather fed up with the parade of hapless lenders and even more hapless solicitors who were going in and out of the witness box. And the judicial temper was getting was being tested by what was going on in front of him. We had to decide which solicitor to call on a particular day, and we put in a solicitor into the box in a case where we thought there was no danger whatever of any form of the judge really attaching any weight at all to the allegations of impropriety which were floating around the edges of the pleading. File looked okay to us. We thought it was all going to go very well. Counsel for the lender was also getting rather bad-tempered and had found in the file a document about VAT, which, carefully scrutinised, did tend to suggest that some form of VAT fraud had been going on, and it was conceivable that the solicitor had been party to that fraud. And after about 5 minutes, the questions were developed in relation to this document, and I could see the judicial eyebrows, which were substantial, being raised. And this went on for another few minutes, and then the learned judge decided it was time to intervene. And he leant forward and said, Mrs. X, I think I can remember her name, but I won't give it. Mrs. X, I think the moment has come for me to remind you that you do enjoy a privilege against answering any questions at all, which might incriminate you in terms of criminal liability. And if you wish to exercise that privilege, then you must say so. There was one of those moments in court that you don't forget. Complete silence. Solicitor raised her head and said, I do wish. And that was the end of the cross-examination and the end of the case. Now, I go to that because that was a case in which the claimant had wisely not put allegations of fraud or impropriety or dishonesty squarely at the centre of the case that was being advanced. The papers didn't justify that. So the case was pleaded low. It wasn't really put in as a case of dishonesty at all. But the temperature was raised in the course of the trial, so that the judge, as the trial went on, started to think, I've got a wrong 'un in front of me. And that is forensically very effective. And that case was won hands down by the claimant, obviously. So that's really quite a good way tactically to deal with a whiff of impropriety. Don't put your case too high. Don't formulate it as some grand case of conspiracy involving multiple allegations of dishonesty. Make the case at the lower level of serious negligence, and then just allow it to emerge that really perhaps something went really very wrong in relation to the handling of whatever the transaction was. If you can do that, you will do well. Right, I'm now going to invite Carola to assist you on the various ways in which allegations of this nature improve your prospects legally.
Thanks, Patrick, and thanks everyone for coming. So, as Patrick said, I'm going to talk a bit about some of the very real tactical and legal advantages to making out a case in fraud, if, of course, the material is there to allow you to allege that properly. So the first advantage is causation and loss. If you succeed in making out a case in fraud, you'll find yourself, or your claimant will find himself, in a much more favourable position when it comes to what losses are recoverable. the basic principle, which I know you'll all be familiar with, is that you don't have to prove that your losses were foreseeable, provided they do flow from the fraud. So Smith New Court is the classic case on that, and often gives its name to this measure of loss, the first case on the screen there. Again, I'm sure everyone here is very familiar with how that case works, but the facts remain quite a neat way to summarise the operation of this measure. So forgive me for going over what may very well be familiar ground. So in Smith New Court, the claimant had bought shares in a listed company in reliance on fraudulent misrepresentations by a broker, and the price of those shares later fell quite substantially. The House of Lords held that the claimant was entitled to recover all losses flowing directly from the fraudulently induced transaction, even if they weren't foreseeable at the point of the share purchase. So the starting point was that the claimant was able to recover the full price he paid for the shares, however bad the bargain was, however obvious it should have been that this was not a good deal at the time of the purchase. Obviously, against that sum, it's still necessary to give credit for any benefits accrued as a result of the transaction. But normally, in a non-fraud situation, that exercise would involve valuing the shares, or whatever property it is, at the date of purchase. When there's been a fraudulent misrepresentation, that exercise will be done on the basis as if all the facts about the fraud had been known at the time. And that's the figure that gets deducted from the purchase price. And a particularly advantageous quirk of this measure of loss is that consequential losses are also recoverable. So again, sticking with the share example, if you've bought shares which you overpaid for slightly in reliance on a fraudulent misrep, but then the price completely crashes because of some completely unrelated market event, if you were still holding the shares under the impression that the misrepresentation was true, so the misrep was sort of ongoing at the time of that market collapse, you can recover all the money you've lost, even though it didn't on its face have very much to do with the fraud. The other point to make on this slide is that pleading and proving fraud is a way around exclusions and limitations of liability. So there's a public policy rule against a party excluding or limiting liability for his or her own fraud, so his or her own deliberate wrongdoing. Most exclusion clauses now have carve-outs for conduct of that kind, but even if the clause does purport to cover fraud, it won't be enforceable. And you've got the case of Chase Manhattan Bank as authority for that proposition. Connectedly, successfully alleging fraud also allows a free ride past a potential contributing negligence defence. Fault under the Misrepresentation Act doesn't extend to intentional torts, and that's essentially because the Act just regulates what the common law position was prior to the Act coming into force, and there's been a long-established rule that there's no contributing negligence defence in respect of deliberate wrongdoing. And the rationale for that is set out by the House of Lords in Standard Chartered. So it would not seem just that a fraudulent defendant's liability should be reduced on the grounds that, for whatever reason, the victim should not have made the payment which the defendant successfully induced him to make. So however careless a claimant may have been, the defendant can't rely on contrib if the cause of action arises from the defendant's intentional wrongdoing. And the same general principle applies to claims that are not brought in tort, but of which are analogous with respect to the contrib principle. So that means that there's also no defence of contrib for breaches of fiduciary duty, and that was decided in Nationwide and Radmore, which you've got on the screen. And that was a claim against solicitors who had acted for both the lender and the borrower in mortgage transactions and were said to have preferred the interests of the borrower. There was no defence of contributory negligence there, despite the fact that the lender had arguably been quite lax in checking out the borrower's creditworthiness. And the same is also true, it seems, of misrepresentation claims under the 1967 Act. That's because the basis of a successful misrep claim is going to be that the defendant intended that the claimant would rely on the misrep. The courts have left slightly open the possibility that in a really exceptional case, contrib might still be available, but it's quite difficult to envisage what sort of case that would be in general. If you successfully pleaded and proved misrep, that will mean there's no scope for a contrib defence. Another advantage of pleading and proving fraud is that it might enable you to get your hands on documents that would otherwise be subject to legal professional privilege. And this is something that those of you who attended Charles and Chris's talk right before this one will probably already know much more about than I do. The essential principle is that there's no privilege in a document that has come into existence in the furtherance of fraud, crime, or another iniquity. And there's very recently been a major decision in this area, which is the Al-Sadek case, the first case on the slide. This is a decision arising in the context of some very factually complex fraud claims brought by the RAK Sovereign Wealth Fund. And the basic allegation is that Decca, the firm of solicitors investigating the fraud allegations, tortured Mr. Al-Sadek, and he was seeking compensation for obvious distress and harm he says he suffered as a result of that. So the Court of Appeal clarifies a lot of important points in its judgment, one of which was to confirm that the threshold for the exemption was engaged when there's a prima facie case of iniquity. So that just means that the iniquity needs to be established on the balance of probabilities. That's a very important and also quite claimant-friendly clarification in several previous cases, actually including Akhmedova, the second case on the screen from 2019. There's been this suggestion that what's necessary is to establish a strong or even a very strong case of iniquity. But in its judgment earlier this month, the Court of Appeal said, no, it's just a balance of probability test that there's been fraud or another iniquity. Next, I wanted to say something about limitation. And again, I think there's been another talk exploring this, I'm sure, more fully earlier today. Another very well-known benefit of successfully alleging fraud is that you might be able to avail yourself of the limitation extension under Section 32 of the Limitation Act. And I've set out the relevant section on the slide, but I'm sure everyone here uses it regularly. Of course, the essential point is that where a cause of action is based on fraud, or the defendant's fraud, and a fact relevant to the claim has been deliberately concealed from the claimant, time won't start running until the claimant has discovered the fraud or concealment, or could, with reasonable diligence, have discovered it. In Canada Square, a Supreme Court decision from last year, there was some important clarification on subparagraph B of that test. So looking at what deliberate concealment entails. In particular, the Supreme Court disagreed with the Court of Appeal that it was necessary to show that the defendant had any obligation to disclose the fact that had been concealed. There doesn't need to have been any duty to disclose the relevant fact, but it's necessary, of course, to show that the defendant intended to keep the fact in question from the claimant. So it's that word deliberately that really provides the limit on subparagraph B. But if you're able to get yourself into that territory, that can be game-changing from a limitation perspective. And finally, in quite broad brush terms and linking back to what Patrick said at the start of this session, one of the most important benefits of pleading impropriety is that if you're able to make good those allegations, you may well find that the judge wants to find for your client. Allegations of this type are serious and require very cogent evidence, but the flip side of that is that if you succeed in proving them, the judge is almost certainly going to be on your client's side and doing what he or she can to ensure your client's able to recover. Those are the benefits. Very briefly, before I hand back over to Patrick, I wanted to flag one potential pitfall of successfully alleging fraud, which is that you might find that it means the defendant's professional indemnity insurer won't pay out. Again, Alison and Dermot, I think, did a talk on this topic this morning. The general principle at play here is derived from old property damage cases. So you'll see on the screen a quote from Beresford and Royal Insurance, in which Lord Atkin held that on ordinary principles of insurance law, an assured cannot, by his own deliberate act, cause the event upon which the insurance money is payable. The insurers have not agreed to pay on that happening. And that same general principle means that a professional can't obtain an indemnity in respect of his or her deliberate wrongdoing. In practice, the issues in a professional liability context tend to be quite a lot more complex than that general prohibition suggests, because normally it's going to be a firm that has the insurance policy and a particular individual who has behaved improperly. So there's a lot of interesting case law, some of it quite recent on that scenario. The starting point, we get this from the case of Hawley, is that absent an exclusion, a policy will respond to liability arising from deliberate acts of the insured's employees. So it's relatively straightforward in most cases. If you've got a firm that has, it's a reputable firm, it has no idea that one particular employee has been behaving terribly, you should be fine as a claimant and be able to recover from the professional indemnity insurer. Things become thornier when there are issues going to attribution or as to the extent to which the insured firm was complicit in the wrongdoing. And obviously, the smaller the firm, often the more likely that is to be an issue when there are fewer people involved. It's more likely you're going to find that the firm as a whole knew about or condoned the bad behaviour. And some recent authority on this is Access and Discovery Land, which Patrick, in fact, appeared in before the Court of Appeal. This was a case involving the misappropriation of client funds by one of two partners in a firm of solicitors. The firm's insurance policy excluded liability for dishonest or fraudulent acts committed or condoned by the firm. And the issue was whether the second partner had condoned the first partner's misappropriation of client monies. And very much on the facts, it was found in that case that the partner who hadn't done any misappropriating, despite having conducted himself quite poorly during the trial and indeed having been dishonest in his evidence, the judge found, and the Court of Appeal didn't disturb his conclusion, that the second partner hadn't known about the misappropriation and he didn't have blind eye knowledge of it. He didn't suspect, and therefore didn't condone it by not doing anything about it. So that decision is, in many respects, quite specific to its facts, but it also illustrates that broader point that you may well find that if you successfully allege fraud, the judge is going to want to find a route to your client being able to recover, because obviously in that case, Access did have to pay out. And finally, a couple of cases at the bottom of the slide about attribution when the fraudulent acts of an employee can and cannot be attributed to the company. And this is an interesting area where the case law is quite unclear. So there's insurance-specific case law, including KR and RSA, the first of those two cases, to the effect that what was described in that case as managerial employees, quite a vague term but referring to very senior employees, can be treated as being, in effect, the company for the purposes of this kind of policy exception. But since that case was decided, there's been some Supreme Court authority on attribution much more generally, not just in an insurance context, including Bilter and Azia and Singularis, the second case on the slide. And it seems unlikely that the approach in KR and RSA is consistent with the formulation the Supreme Court has given in those more recent decisions, which say it's necessary to consider the context and purpose of the acts in question in order to decide if they fall to be treated as the acts of the company. It's not just a question of the status of the wrongdoer. So that is what I had to say about the pros and cons of pleading fraud from a legal perspective. I'm going to hand back over to Patrick.
Thank you very much. Thank you very much, Carola. I'm going to end the talk, hopefully leaving time for one or two questions, with a few practical observations. I wasn't going to mention the Axis case, but since it's been raised, I will just note that it is an illustration of how dangerous it can be to rely on what appear to be well-founded allegations of impropriety, because if you consult the judgment in that case, you will find that there were findings that the solicitor in question lied about material matters on multiple occasions, and indeed was unsuited ever to have been a solicitor. That might have led to a finding of condemnation, but it didn't. These are the surprising and adventitious and sometimes unsatisfactory things that can arise when these matters are fought out in front of judges. Now, a few practical observations, seeking to bring the threads together. What one gets, I think, from the excellent legal points that Carola has made is first of all this general rule: the weaker the claimant's case, the more tempted the claimant's advisors should be to formulate a case in dishonesty or involving some sort of allegation of impropriety, because that can have good outcomes. So if you've got limitation problems, well, you may want to look very closely at that possibility. If the link between the breach of duty or the misconduct or whatever it was that the professional did wrong on the one hand and the loss on the other is very tenuous in terms of causation or in some sort of moral sense, giving rise to potential Samco or Manchester Building Society arguments, etc., then you may enhance your chances of a good outcome by alleging impropriety. The more careless and cavalier and reckless you have been as a claimant, well, that's another good reason for looking closely at the possibility of alleging impropriety. One gets those obvious practical points, I think, from what Carola has been speaking about. Now, just one or two practical points about procedure when you get to court. If you have pleaded the case, obviously you have to comply with the exacting rules about pleading fraud. If you've actually pleaded a case in dishonesty or conscious impropriety, then you have to put it. You have to put all relevant points to the relevant witness or party, and if you don't, you might fall foul of the rule, what's called the rule in Brown and Dunn, and you might be shut out in the Court of Appeal from relying on those points that you did not put. That's well known. What's less well known, but highly significant in my view, is this. If you don't plead a case in dishonesty or impropriety, but you do put to the relevant witness potentially wounding allegations involving lies and dishonesty and impropriety, etc., and the judge says, your opponent stands up, or the judge says, well, what's this all about? You haven't pleaded this case. Why are you cross-examining the witness about all these damaging matters? You say, well, I'm entitled to cross-examine as to credit. There's no limitation on the matters that I can properly put to the witness as to credit. Fine, you can say that. That's a good answer, and you're allowed to put the questions. What is often overlooked, though, is that there is an old rule, which you can find in the books about evidence, that answers to questions which are solely concerned with credit are final. They cannot be rebutted. They cannot be tested. Further matters cannot be put to the witness to show that his or her answer on the issue that goes solely to credit was wrong. Sometimes practitioners overlook that, and that is another reason to be quite cautious about about excluding allegations of impropriety from the pleaded case. If the case is well handled at trial on behalf of the defendant, you might find the scope for damaging cross-examination is significantly limited. Right, last practical observation, last thoughts about this matter. What are practitioners to do when they're trying to work out if they're going to be able to prove, make good the case that is built on dishonesty or impropriety? How are they going to work out whether they're actually going to win? Well, on the claimant side, obviously one looks very carefully at the documents, usually now obviously emails, because one bad document, just one, can often be enough. One document that simply is incapable of being explained otherwise than on the basis that the witness or party was acting dishonestly, that can be enough. And indeed, there are plenty of cases in which judges have made that observation. But one needs to be a little cautious about that. Take the position of a lawyer handling a complex transaction. We all know, everyone in this room knows, that life is not perfect and mistakes do happen, and sometimes the job that we do is tricky. Judges know that too. And judges will be alive to the possibility that what looks like an incredibly damaging document, which can only have been composed by a dishonest person, was in fact just a terrible mistake. An email flicked off at 1 in the morning, something of that sort. So if you're working out how a judge is going to react to what looks like a very bad document for the other side, think hard about motive. Because if you don't, the judge will. The judge will say, well, that's very interesting, Mr. Lawrence, you're making a lot of this document, but what reason would X have had to lie to his client or to the other side or whatever it might be? What would the reason be? Potentially a career-ending thing to do. Where's your case on motive? That's something that needs to be borne in mind very carefully indeed when working out one's chances of succeeding on these allegations. And then finally, on the defence side, if you are facing one of these cases, an impropriety case, what to do? This is really almost too obvious to be worth stating, but it may be just worth emphasising this from my own experience. There is no substitute for a very old-fashioned, very meticulous, very time-consuming approach to proofing the witness on the key documents, which may be file after file of emails which are pertinent to the allegations that are made against the witness. There is no substitute for sitting down with the witness, some lawyer who knows the case very well, not coaching the witness in relation to the evidence, one's not allowed to do that, but working out what the witness really has to say about the emails. That can take a lot of time, but if you're facing an allegation of dishonesty or conscious impropriety, there is absolutely no substitute for that, and that should be done. It almost never is, for reasons of expense and time, etc., but it probably should be done before one even pleads the case in response to the allegations. That is quite enough from me. Thank you for listening. What's the time, Carola? Have we got any time for questions?
5 minutes, yeah.
We've got 5 minutes or so. So I would be very grateful if anyone has a question. If not, we can go and have lunch, but there may be some questions. I'm going to ask one of my colleagues a question about this subject, unless they come up with an intelligent question. Charles. Okay, you've heard enough. I don't mind. I'm not hurt. Time for lunch. Thank you very much indeed.